kicked me out when I went to teach. So you get two videos for this one. So let's get right back into it. We were talking about Samuel Chase and how he was removed for what they would call bad behavior, but realistically, he was actually just removed because he's a Federalist, which is against the law. And so he was reinstated. Um, Jefferson was kind of a little bit of a whiny baby about opposition as far as it goes. Okay. So Supreme Court, just to review where we were talking about good behavior. We were talking about the actual process and that judges are for life. And that this is the court of last resort and you need to know who's on it and don't use the writ of the granting in your writing, the Latin granting. So here's that recap again. We have a hierarchical structure. We're focused on jurisdiction and venue. The difference is going to be whether the case is pursued federally or whether it is state, and that has to do with the violation. The federal cases go through district court, which is court of original jurisdiction. State cases go through trial court, court of original jurisdiction. This is where the facts are decided. The facts are decided. Then if post-conviction, there is concern about the procedure or the alignment to the law, then you can go to the Court of Appeals. Now, the circuit courts, we are the Fourth Circuit, and so that's where our federal Court of Appeals is. In a state case, you would go to the first level of appellate court. There is another means by which you can actually have an appeal heard. It's not another, but it's the next means, and that's if you are granted the Supreme Court, a hearing by the Supreme Court. At the state level, you do have another version for appeals, which is a state Supreme Court, but then it can go to the U.S. Supreme Court. Now, if we are looking at a felony case, so now we're saying, is it a misdemeanor? Is it a felony? Is it civil? Is it criminal? Is it state? Is it federal? So we're going to look at a federal felony, a federal felony, and the process by which we go through. So you're going to see that consistently a felony is going to be described as any crime where you could be imprisoned, like you could be punished with death or imprisoned more than 1 year. More than 1 year, you're supposed to go to prison versus jail. Right now, we're pretty backed up in our prison system. So really, you might, if you have less than 2 years, you might stay in a jail. But generally speaking, or on paper, the rule is 1 year. And you'll go to prison. Before that point, sorry, if it's less than 1 year or it's only punishable by a fine, then that's going to be a misdemeanor. Okay. Okay. These are questions you should be able to answer without looking at your notes. So we're going to look first at what happens in a state with no grand jury. Grand jury is a right through the Constitution. It is required in federal cases, but it has not been incorporated to the states. It has not been incorporated to the states. So not every state chooses to have a grand jury system. In North Carolina, oh, I see what it is. In North Carolina, we do. The other thing is if you watch Law and Order, they do in New York. And so it's a great place to see the grand jury in action. You'll see this pop up, go away, come back, go away, come back. The number one thing that we have to know is that it has to start with some sort of incident, some sort of alleged offense. If there is no alleged offense, doesn't matter. Nothing else matters. So most often, police, law enforcement they don't come upon crime. They are called to a scene through a call for service, usually through 911. Remember, that's only 20% of police work. 80% of police work is social work, but 20% is like crime fighting. And most often they will be called to service. They don't encounter crime. They get there, they have to prepare this report. The report is about what happened, who did it, what were their observations, witnesses, just a general description of what's happened. That report will then go to the prosecutor. The prosecutor is going to review that report to decide if there is probable cause to move forward with the case, to pursue the case. During this time, the offender is in jail, usually, and we have this usually done within 24 hours. We'll have their charges officially read to them. We have to have the charges officially read because of our writ of habeas corpus that we have written into the Constitution, in the original Constitution, right, for citizens' rights. When it goes to the prosecutor, you will be amazed at how much power a prosecutor has. If you want to make changes in the system, right? If you want to be active and involved in the system, being a prosecutor is the way to go because they have so much control and so much choice in what they do and what makes it through the court. They are really, really going to be like our gatekeepers. Now, if you want to make money, defense attorney, but if you want to make a difference, really the prosecutor just has so much power. There are a lot of points for change that you can make. Now, they can decide whether to bring charges. Does that probable cause exist? If it does exist, do we want to move forward with the charges? Otherwise, the person is going to be free to go. Do we want to investigate any further? Is there more information that we need to gather? How do we prepare this case? Do we want to grant immunity for whatever scenario, right? Whatever scenario we might want to utilize immunity as a bargaining chip. And then if we choose to use that immunity, are we using that as part of a plea bargain? And if so, does the prosecutor decides if they're even going to accept a plea and what conditions they will accept it under? It isn't, obviously the defense has a portion, right? They have this idea that, yes, I will accept this. I won't accept this. No jail time. Yes, jail time, whatever it is. But the prosecutor can reject it at any point, and it's a non-starter in those cases. Now, when we talk about plea bargains, though, sometimes we put the prosecutor and defense attorney, we put them as adversarial. They're working together for the same goal. Oh, whoops. See, there's your recording from before. And that goal is to end the case, right? As cost efficiently as possible for the defense attorney getting paid by the hour. And you're hired, you're going to want to extend it out. If you are a public defender, you want it to go fast because it's all free work, basically. And if you're a prosecutor, you want to get these cases off your desk. So ultimately, plea bargains benefit the system. Our system is not designed for every case to be decided. We can't handle that. We would be too overloaded and overwhelmed. So plea bargains are crucial in our system. But if you end in a plea bargain, you give up the right to appeal. You give up the right to appeal. So any of those appellate court processes, including the Supreme Court, are immaterial to you. You've given up that right. So then how many cases actually end in a plea bargain? It's like 90 to 95%. Unbelievable. So this is it. I mean, everything about this case is going to be decided by the prosecutor, particularly in a non-grand jury state. So the prosecutor has unbelievable power over the process. Now, there are two restrictions as far as, like we say, unbelievable power and almost unlimited. It isn't unlimited. There are two things that they cannot do. Number one is they cannot selectively prosecute. They cannot selectively prosecute. That means that if, and the prosecution, we're going to err on the side of the prosecution. We're going to say that they were fair. So in this case of selective prosecution, it is up to the defendant to prove that it was selective prosecution. And that means that it was based on a non-legal standard. Their prosecution is based on a non-legal standard. Probably the easiest example I can think of, I think it was in Austin. No, it wasn't Austin, on 6th Street. That's like Party Street. I think it was 4 men, 3 white, 1 black, that were drunk in public, walking on the street, right? They got spoken to. They were, there was nothing different between them. There was no additional offenses or no outstanding warrants or anything like that. Well, only the black man was arrested. Only the black man was arrested. No, I'm sorry. They were all arrested, and the prosecutor chose to only pursue the case against the young black man. Nothing else was different. There was no other difference, but the prosecutor chose to only pursue against that one of the 4. That was a case of selective prosecution. The others were similarly situated, basically the same situation. The only difference seemed to be race. And because that is the only apparent difference, and it is a non-legal factor, it means that there's a case for selective prosecution. And then in Yickwo versus Hopkins, this is a case where we were that's not anything, right? We were very particular about Asian communities. And so they were enforcing some code violations and registration, blah, 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 for laundromats, I believe in San Francisco. And there were white-owned laundromats nearby with the same issues. but they were only pursuing those owned by, the police were only pursuing, nope, sorry, the police were citing everybody, arresting some, and the prosecutor, was only pursuing the cases against the Asian community. So the only difference again was nationality at that point. So for us, we can see those are clear cases of selective prosecution, very much based on race, but it can be any non-legal arbitrary factor, right? So we have to be careful about these implicit biases that we have, these innate biases. The other restriction to prosecutorial power, so remember that they have unbelievable power, but they do have two restrictions. One is that they may not selectively prosecute, and the second is they may not vindictively prosecute. So this is if a defendant says, I plead the fifth, or I refuse to speak, or I'm not going to waive my rights, or I am not going to discuss a plea or something like that, the prosecutor can't change the charges or up the charges. They can decrease charges, but they can't penalize them for not cooperating, because they have the right to, you have the right to not incriminate yourself, right? The law, use it, don't speak, right? You don't have to waive any of your rights to search and seizure or anything like that. You can acquire the warrant, you can go through all of those steps, and there is no scenario where the prosecutor is allowed to increase the penalty as a response to you exercising your constitution. So again, police arrive on the scene, but what had to happen? Bum, 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 an offense is committed. So police are likely to call for service through 911. They prepare the report goes to the prosecutor. This is in a non-grand jury state. The prosecutor determines if there is probable cause to continue the charges, to pursue through the court system. If there's a complaint that is made through oath and affirmation, and they are saying that I swear that there's probable cause, blah, 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 blah. Okay. They issue a warrant or a summons to complete the trial portion. Oh, for goodness sake. And here is the actual complaint, which you can see in the supplemental handouts, I believe. There we are, okay? And this is saying that they must appear in court. You don't have to be out of court for this to occur, or out of jail for this to occur. You might have the summons or arrest warrant put into place. The summons if you are in court, or the arrest warrant if you need to be arrested. You have not yet been arrested. They've been collecting data and facts, because remember that they have the right to authorize, the prosecutor has the right to authorize investigations. And so then you would appear in court. Now there are time restrictions on this. Once you have been arrested, you have your initial appearance. Your initial appearance is where they read the charges to you. From the moment that you are officially arrested or incarcerated, basically, processed through intake. So you go to intake, you get your fingerprints, you get your sweat, you get all that stuff. 48 hours, you must be in front of a judge or whatever, or a magistrate, to have your official charges read to you. Anything beyond 48 hours, and then they have violated the habeas corpus expectations in the United States, and you are unable to be charged unless there's an exceptional reason. Then after the initial appearance, boop, 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 we want to verify who you are, because we have had the wrong person before, of course. They need to know exactly what they're being charged for. Remember, it cannot be vague for fear of double jeopardy. So we have to have, it's due to habeas corpus, double jeopardy, and then just our speedy and public trial. People must be allowed to prepare their own defense, and that's in that bill of attainder, right? We appoint an attorney if they cannot afford one. Please note that public defenders come from a variety of places, but they are low paid, if not unpaid. And they spend, I think the study said, on average, 8 minutes with their clients beginning to end. So what will happen is they'll bring everybody from the jail or to the room or whatever it might be, put them in front of the judge, and the attorney is basically like, hi, my name is Tiffany. I'm your attorney. Are you Joe Smith? Yes. Okay, these are the charges against you. Yes. Okay, we're going to go in there. We're going to plead not guilty. The judge is going to say this. They're going to be taken right back. Like, that's our conversation. And so this is where they would get that chance to have that attorney for that next stage, but they still it doesn't guarantee them time with the attorney. Okay. You have to be Mirandized if you've been arrested and we are collecting evidence against you. It's going to protect them from being left in jail, forgotten. That's a rule because we've done that. We have done that a lot more than I'd like to say. And then if they need to get bail, if they're offered bail, which is not always done during the initial appearance, so it can be, they are offered bail, they are allowed to try to get bail through a phone call or through a family member. Bail is an assurance that you will appear at your trial. So if your bail is $1,000, you pay $1,000 to the court, you leave, go home, whatever it is. Then on your court date, you come back, you get your $1,000. Okay. Oh, there you go. So where's bail found? We talked about this. It's in line with the cruel and unusual. We're talking about the Eighth Amendment. It's the perceived evil, right? We're talking about the perceived evil. So it's perceived evil. I'm saying, in light of the perceived evil. Proportionally determined. Oh man, I've forgotten it. It'll come to me. But the perceived evil is dependent on the seriousness of the offense, your prior criminal history, the likelihood that you will or will not show up. So means, connections to the community. If you have children at home, somebody who depends on you. If you have a passport and $1 cajillion in cash and you bought 3 plane tickets to different non-extradition nations, right? Then no, we're probably not going to give you bail, right? I just totally spit. We don't have to. Nobody's guaranteed bail, but it has to be reasonably calculated in light of the perceived evil. Got it. Reasonably calculated in light of the perceived evil. So in this case, that perceived evil is going to be based on your history and the offense that you are being charged with. So if we're going to talk about the likelihood that you show up, if you have a job and we can release you if you haven't already lost your job, then you're likely to have some sort of tie or connection to the community and desire to get this over with, right? If you own property, it's very difficult to offload property legally. And so if you have home ownership, if you're employed, if you have a family, are you a member of a church, are you on a committee, what kinds of things, what types of things are going to represent your connection to the community and your desire and investment in having this case settled. Now, what I want to point out to you is that most of these are characteristic of adults, much older adults. And so though the average person coming through the court system is going to be a young Black male, this is representing people who are in a little bit older, more established, with better financial backgrounds at that time. And so this does not represent the average offender. So there is concern about bail being discriminatory and the fact that it's essentially the price of your freedom. It's essentially the price of your freedom, because we then, if we choose not to give bail, or we give a bail that is not, it is reasonably calculated in light of perceived evil, but is not reasonably calculated in light of the defendant's ability to pay, then what will happen is people are being incarcerated, which is the equivalent of it's exactly what their sentence might be, right? And so we start to see that there's a loss of liberty, loss of freedom, in some cases a loss of life, related to simply not being able to afford to pay, and you have not yet even been convicted. Okay. This case makes me laugh so much, and I'm going to try to share the sound with you because I would like you to see this. But we'll get to see that initial appearance, which is not very exciting, but what it does, it allows you to see how quick and how informal it feels that initial appearances are in the true court system. Okay, so this is the case of Comic-Con incident.
But first, armed to the teeth and set to kill no matter who got in his way. Tonight, chilling new details revealed about the carnage this Valley man admits to plotting before his arrest at Phoenix Comic-Con. Now, thousands are forced to wait hours to get through enhanced security measures after police admit he just slipped through an unlocked door.
ABC 15's Chris Groh is digging deeper into Matthew Sterling's plan. And Chris, we have heard about him taking pictures of officers, but then you found out who he was really targeting.
Yeah, an actor, and his name is Jason David Frank, and this is his autograph booth right here behind me. You can see right there, he's known for playing the Green Power Ranger in the 90s children's show. Sterling told detectives he was there to kill Frank and even had a reminder on his phone. This is our first look at Matthew Sterling up close, a 31-year-old suspect posing for his mugshot, a trace of black face paint barely visible. But this is how the man saw himself Thursday as the Marvel character The Punisher, a violent vigilante ready for a gunfight. According to court paperwork, Sterling walked into the Phoenix Convention Center purposefully evading security, carrying a load of weapons similar to The Punisher.
He was armed with a shotgun, 3 handguns, numerous rounds of ammunition, a tactical knife.
I'm told all of Sterling's guns were fully loaded. He spent the day taking pictures of cops and sending Facebook messages to a woman he met, telling her he would shoot them.
Always just going through my mind, what if I didn't do anything? What if people died?
She immediately took action, calling police, alerting them of what she was being showed and told. After his arrest, Sterling told police he'd come to Comic-Con to kill this man, Jason David Frank. Frank played the Green Ranger in the Power Rangers show. Sterling claims he stabbed Frank 15 years ago and wanted to, quote, finish the job. We've reached out to Frank's representatives, but so far we haven't heard back. I'm told he's still planning on fulfilling his schedule here at this weekend's Comic-Con. As for Sterling, he's being held on $1 million bond. Reporting live in Phoenix, Chris Crow, ABC 15, Arizona.
All right, Chris, thank you. Sterling's arrest leading to major security changes at the event, and you can see the impact it made.
He had a reminder on his
Air
phone.
15 here, Captain.
Kill Green Power Ranger, right? So this is the case, right? Matthew Sterling, he comes in, it's attempted first degree murder. He's contacted the man before. And the Green Power Ranger, he actually died very recently, like in the last year, but not from this. So these are all of the charges against him and all of these things. And it was an intense case. It was a unique case. Violence is very unusual. So it was it's unlikely for something like that to occur again. So we can look at his appearance here, and I'll tell you my favorite part of this initial appearance is watch them. They're so bored with this like boring guy, and then they hear his charges, and you just see like something interesting's happening, right? So this is the initial appearance. So if you were here, and these are all being charged as well, right? So if you are here for women are usually forgery, sex work, drug running, something like that, right? So let's say they're here for whatever it is, and then they are getting the same treatment, same situation as Sterling. So we'll listen to this.
Your full name?
Matthew Enrique Navarro Sterling.
All right, and I believe the county attorney is present and is going to want to make a statement. If you could identify yourself, please.
Yes, Your Honor. Ed Leiter with the Fairfield County Attorney's Office.
All right, Mr. Sterling, you're here on the following charges. 1 count of attempted murder in the first degree. That's a Class 2 felony. 3 counts of attempted aggravated assault with deadly weapon or dangerous instrument, Class 3 felonies. 1 count of wearing body armor during a felony, a Class 4 felony. 1 count of aggravated assault on a police officer, a Class 5 felony. 1 count of resisting arrest, a Class 1 misdemeanor, and carrying weapons into a prohibited place, a Class 1 misdemeanor. I have appointed an attorney to represent you. Your next court date is June 2nd at 8:30 in the morning. The county attorney has indicated that he wants to make a statement and provide some information to the court. He has the right to do that, so I'm going to allow that.
Briefly, Your Honor.
And that's very unusual.
Mr. Sterling attended the Comic-Con convention yesterday morning. Was dressed in specific costume gear as the Punisher. He was armed with a shotgun, 3 handguns, numerous rounds of ammunition. JDF is Jason David Frank, who is a performer who was actually on stage last night at the Comic-Con convention. Mr. Sterling, during his interview with the police, had numerous fantastical stories, and there certainly is, he exhibited a
Very
dramatic
unusual for
threat.
somebody to speak against the
So
defendant.
it's, in my opinion, it's
At
not in
initial
your best interest to make a statement. I can't prevent you from doing so. Do not do anything you say could be used against you at here and future court proceedings. Everything's being tape recorded. So it's, in my opinion, it's not in your best interest to make a statement. I can't prevent you from doing so. So Are you choosing to not make a statement?
I will not make a statement.
All right. Based on all the information that I reviewed, and there was quite a bit of information that was provided by the police, I do find that $1 million cash-only bond is appropriate in this case. If you're able to post that bond, you're not to return to the scene of the alleged crime, you're not to have any contact with any of the intended or alleged victims, 0 weapons of any kind, no drugs without a valid prescription. If you'll step to the clerk, she'll have your paperwork.
And that's it, right? So we have this initial appearance, which is basically the same as as dry, sorry, that's the third word, as dry as it would be for just a mundane crime event. And it's the same thing. It's just like, here's your attorney. I'm going to appoint your attorney. Here's your court date. Here's your bail. Let's move on. Next person. You know, you're talking about such a fantastic event as far, not fantastic, it's a positive, but it's a high profile event. And his whole initial appearance was less than 3 minutes. There was no warrant for his arrest. There was no warrant issued, and that is because they caught him in the act. The crime was witnessed, right? So you don't have to have an arrest warrant based on probable cause. Okay. So what's the very first thing that happens? Dun, 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 dun. Offense is committed. Arrive on the scene, prosecutor reviews, decides to charge. We have the official written complaint. We have the warrant or summons offered. Whoops. Then we have the initial appearance within 48 hours. You have a right to know what charges are against you. Bail is typically set at this stage. And then you have a preliminary hearing. So the preliminary hearing does a few different things. They review, this is really just a formality, but they review the probable cause, and it has to be within 10 days of the initial appearance. So right here, it could be if you wait 48 hours for the initial appearance, then it's 10 days after that. So it could be up to 12 days, but if it's on a test question, we're looking at 10 days, right? It has to be within 10 days of that initial appearance. If you do not have that, which you can waive it, but if you do not have that, it's just a that done, then you again have a cause to say that there was a violation of your procedural rights, due process rights. So again, this is just formal. Indigent is a word that's used very often, and I do want you to really take a look at that. Indigent just means what equates to poor. That's not what it means, but it's basically poor. You cannot afford an attorney. One can be represented, one can be appointed for this stage that your right to an attorney takes hold, right? So at the initial appearance, you are not guaranteed representation by an attorney. But starting at the preliminary hearing, you are entitled to an attorney. Now, again, you have that 10 days after the 48. If they do formally agree that probable cause exists, then you're going to be bound over for a trial, whether that's released on bail or whatever that may be. But again, this is going to be just the formal recognition of what that initial appearance is. Probable cause is a really clear term that we're going to use very often. And this is 3 things. It's based on facts. So you have facts and evidence. Facts and evidence that a crime has occurred or it is occurring. You know who was involved and you know what they did, basically, or what kind of evidence you're going to find. So we're really just looking for a 51% here, right? Probable cause is 51% likelihood that these things happen. We know who it was. We know what they did. Not what they will do, because we don't prosecute on the future, but what they did have done. So after the preliminary hearing, you see that there's an arraignment. Very frequently the initial appearance, preliminary hearing, and arraignment will be together, but if not, at least the prelim hearing and the arraignment will be held together. During the arraignment, this is when you enter your plea, and your plea can be guilty. Now look at this, please. Guilty, not guilty, nolo contender, and then NGRI, not guilty by reason of insanity. Not guilty by reason of insanity or mental disease and defect, depending on where you are. Very few cases will ever do that, because if you have that, if that is accepted, then you go into mental health care facility. Those are dreary at best. So if you plead guilty, that can be used against you, D is defendant, in the civil suit. Because remember, it's not double jeopardy between criminal and civil, because there are different cases. And so if you plead guilty, that can be used against you as a confession to what happened and what you did. what do they call it? Allocution to the offenses. And so that can be used against you in a civil suit where generally you would owe the family money or something like that. The nolo contender is when you're protected by a civil shield. So this is what you would see from peace officers, etc. You might choose to plead guilty and the court may not accept it. They are looking for a few things. And this is the judge's decision here. Usually the congruence between the judge and the prosecutor's decisions are going to be nearly 100% aligned, but the judge can reject a guilty plea. So they will look for these criteria. Number one, did you commit the crime? And that probable cause determination is going to be what sets us up for that criteria to be met. So we're looking at 51% probability, right? Or not probability, but likelihood. Do you understand what the police says? And were you coerced in any way? And are you competent to know that you are waiving your rights? There is no appeal. There is no conversation beyond this point. A guilty plea or a plea deal is a guilty plea. So it is a guilty verdict against the defendant. It is a guilty charge. So when we say, I don't know, 28% of people were found guilty in the past 6 years, or I don't know, whatever it would be a lot higher than that. We're also addressing pleas, plea bargains. And these plea bargains, so it would probably be like 95%, are where people are saying, okay, I will say that I'm guilty. I will say that I am guilty, usually to relieve pressure of an intense sentence, to get lesser charges, to be released sooner, to reduce the financial strain, something like that. But if you are not shown to understand it, if there's a question about whether you actually committed the offense, or you do not understand you're waiving your rights, the court will reject your guilty plea. So this is where we have arraignment. Oh no. Arraignment is where we are going through your actual plea or your actual, it is a plea, right? Your actual statement of guilt. And so you might go for a plea bargain. 90 to 95% of cases do. Otherwise, you're going to end up in an actual trial. And if you choose to go to trial, like I said, you can have a bench trial or you can have a jury trial. Depends on what's being offered by the court. But plea bargaining here, I do want you to watch this video. It's probably John Oliver, if I know me at all. Actually, I know it is. But plea bargaining is essential. It is essential and it is questionable. So I do want you to take a look at that. After that point, right, after arraignment, if there is no plea bargain, then you would go to trial. And then if you are found guilty at trial, then you would get your sentence. All of those things are happening in the court. Now, the same steps start when we look at the grand jury, but the difference here is that the report is sent to the probable cause determination made by the prosecutor, same, but then instead of that oath or affirmation, the complaint is sent to the grand jury. The grand jury can review the complaint and they have a hearing where they can request additional evidence. The defendant is not present. The defendant's lawyer is not present. This is not about what is your case. This is not about setting up a defense. This is simply about what evidence does the prosecution have against you. If they agree that probable cause exists, then they will indict the defendant with a true bill. So instead of charging them, they indict them. And then you have your arraignment has to be within 10 days of that indictment. Okay, and so here are the differences. And then the rest follows, right? Plea bargains, arraignment, all of that. I'm trying to hurry because my computer's going to die. We determine the probable cause. Initially, the grand jury does that, and then the prosecutor does that. Actually, prosecutor does it first for both, but then it's submitted to the grand jury. The preliminary hearing, if we have that instead, which is a state with no grand jury, then we will bind over the defendant versus issuing a true bill. Preliminary hearings are public. Grand juries are secret. This is all behind closed doors, and they can ask anything they want. There's no judge, there's no defense attorney. The defendant sometimes isn't even there. They can request it, but it's really unusual that the defendant will testify. Preliminary hearing is based on the evidence collected by the officers at the time. Grand jury can ask for experts. They can ask for anything related to the event. And they can interrupt and ask questions, and none of that has any standard of proof. The jury cannot subpoena any witnesses or ask for additional evidence. The grand jury can look at whoever they choose. They can say, I'd like to talk to his mother for character. And it's like, well, okay, got to do it. So, yay. So for us, when we say the grand jury system, is not incorporated, it means it's not required in every state. The federal government has allowed that to be a state by state decision, but North Carolina has opted for the grand jury system. So it is my expectation that you know that and have a sense of what the grand jury does. Now, those are secret hearings, so how will you know, right? But that's why I would love for you to attend a court case. You know, that's why I'm asking you to attend a court case. So I'm going to stop now so that I don't lose you. So let me stop.